We opened our doors for business in London over 40 years ago, and we're still trading on the same values now as we did then. Professional, dedicated and trusted. We are the MECO Group.
I'm going to talk about the case of the CMA CGM Libra. This was a case that was recently heard in the English Admiralty Court. The case concerned a heavily laden container ship which grounded whilst leaving her load port in China. As a result of the grounding, a salvage operation was required, which cost the owners some 10 million US dollars. The owners made a claim in general average against the cargo interests in order to recover some of this sum. Certain cargo interests refused to pay the claim on the basis that the grounding had occurred as a result of the fault of the owners. However, it wasn't enough that the cargo interests could show fault. This fault needed to be actionable. Cargo interests alleged that the owners were in breach of their seaworthiness obligations. Due to the Hague-Visby rules, the owners didn't have an absolute obligation as to seaworthiness. Instead, they needed to show due diligence at the start of the voyage. The court ultimately held that the failure by the master to have on board an adequate passage plan did constitute a failure to exercise due diligence as to seaworthiness. The vessel grounded on an area of shoaling that should have been marked as a no-go area on the vessel's plan. Under cross-examination, the master admitted that had the passage plan properly shown this no-go area, he wouldn't have ventured into it and the incident wouldn't have occurred. This was enough to show causation. Although general average has a particularly long history, general average claims often come as a surprise to cargo interests who don't understand why they should have to pay for a claim that, in their view, occurred as a result of the fault of the owner's vessel or master, whether that's actionable or unactionable fault. Finally, it's worth noting in this particular case that the vast majority of cargo interests agreed to pay the general average claim without disputing it in any way. It's often going to be worthwhile for cargo interests faced with a sizable general average claim to take some time to investigate whether there may be any defence. It's also worth remembering that an owner may be in breach of his seaworthiness obligations even if there's nothing physically wrong with the vessel.